Okay, let's jump right into this explainer. If you've ever worked from your living room, you already know the drill, right? The lines between your work life and your personal life can get incredibly blurry. Well, today we are going to completely demystify the dense legal jargon of Mexico's federal labor law and the new NOM-37 regulation. We're going to break down exactly what this legislation means for the actual day-to-day reality of working from home. So, whether you're an employee trying to figure out what you're actually entitled to, or an employer trying to navigate compliance without making a misstep, we're going to look at how this law fundamentally balances rights and responsibilities.
Here is our roadmap for today. We'll cover 1. What telework is. 2. Employer obligations. 3. Employee duties. 4. Occupational health and safety. And 5. Voluntariness and reversibility.
All right, Section 1. What is telework? The legal baseline.
So what's really fascinating here is that just because you open a laptop at home doesn't legally make you a quote-unquote teleworker. According to Article 330A of the Federal Labor Law, the magic number you need to remember is 40%. The absolutely crucial point here is that these powerful legal protections only trigger when your remote work accounts for more than 40% of your total working time. I mean, if you're just quickly checking emails from the couch on a Sunday, or you take an occasional or sporadic remote day here and there, the law explicitly states that simply does not count as telework.
The law is very precise. It defines telework as subordinate work performed away from the employer's physical establishment. But pay attention to the key phrase here. It primarily uses information and communication technologies. This means true telework requires technology for contact and command. We're talking software, networks, apps, and devices. This firmly sets it apart from those traditional, old-school work-from-home setups that really didn't rely on constant, real-time digital connection.
Moving on to Section 2. Employer obligations, the employer side of the scale.
So instead of you hunching over a kitchen stool and paying for everything out of your own pocket, Article 330-E strictly obligates the employer to set you up for success. The employer absolutely must provide, install, and maintain all your necessary equipment. And the law gets very specific. This includes computer equipment, printers, and yes, ergonomic chairs. But wait, it gets better. They are legally required to assume the costs derived from telework. That means paying for your telecommunication and internet services, and even covering a proportional share of your home electricity bill. How great is that?
Now, I know what you're probably thinking. With all this company equipment sitting in your house, what about surveillance? Are they watching me? Well, listen to this direct quote from Article 330-I. Employers can only use cameras and microphones to supervise you in an extraordinary manner, or when the specific nature of your job absolutely requires it. That's it. The law actually guarantees your right to intimacy in your own home. Any supervision mechanism has to be completely proportional to its objective and fully 100% respect data protection laws.
But, to balance the scales, providing all this gear inherently means the employee has to step up. While the employer is out there providing and maintaining that nice ergonomic chair and your laptop, you have a legal duty to guard and conserve them with the utmost care. It's a two-way street. Which brings us perfectly to the worker's responsibilities.
Let's look at Section 3, Employee Duties, Balancing the Scale.
According to Article 330-F and the NOM-037 regulations, the employee isn't just sitting back as a passive recipient. Look, if the company is paying for your internet and your electricity, your legal duty is to report those costs accurately and, of course, in a timely manner. You also have to strictly follow established health and safety protocols. The law even goes so far as saying you have to submit to required medical exams. And crucially, you've got to follow the company's data protection and storage policies. Remember, you are handling sensitive corporate data right there in your living room, so adhering to digital security restrictions is a strict legal requirement. You can't just brush it off.
All right, Section 4, Occupational Health and Safety, Well-being and Boundaries.
I want you to be really honest with yourself for a second. How often does the line between your living room and your office completely blur? Like, how often do you answer a quick Slack message at 8 p.m. or check an email on a Saturday morning just because it's there? Well, under this Mexican labor law framework, there is a very specific, legally mandated answer for exactly what happens when your shift is over. And the answer is the right to disconnect. This is a massive, absolutely game-changing pillar of the new regulations. It means you have a legally protected right to completely ignore digital communications once your workday ends. And we're not just talking about the evening hours. The law explicitly states this right to disconnect applies during your agreed-upon rest breaks, outside of working hours, and during vacations, personal permits, and leave. Basically, your time is officially your time.
And this right to disconnect ties into some really broad psychosocial protections. The NOM 037 regulation demands that your remote workspace isn't just a physical location, but a truly safe one. It needs to be clean, well-lit without glare, properly ventilated, and quiet enough for you to actually concentrate. But the law goes even further than the physical space, acknowledging psychosocial risks. It mandates a gender perspective that allows for flexible hours to balance family responsibilities. It provides specific, legally protected time breaks for nursing mothers, either 2 extraordinary half-hour breaks a day or reducing their workday by 1 full hour. And perhaps the most surprising yet vital protection, employers must have mechanisms in place to allow victims of domestic violence to immediately return to the office, whether temporarily or permanently, to ensure their physical safety.
And finally, Section 5. Voluntariness and reversibility. The escape hatch.
So, the real kicker of Article 330-G is that shifting from in-person work to telework must be entirely voluntary. You literally cannot be forced into it, unless there's some accredited case of force majeure. But if you do choose it, you retain the full right to reverse that decision. This step-by-step process we're looking at proves that telework comes with a built-in escape hatch. If your health or safety is ever compromised, or honestly, even if returning just aligns better with your personal workplace interests, you have the legal right to invoke the reversibility clause. You just inform the employer, use the mechanisms you previously agreed upon in your contract or union agreement, pack up that ergonomic chair, and head back to the physical office.
So, as we wrap up this explainer, I really want to leave you with a question to spark a little audit of your own workspace. Look around your home office right now. Are you paying for your own internet? Do you have an ergonomic chair provided by your company? Are you fully disconnecting when your shift ends, without any fear of reprisal? Because listen, if you are spending more than 40% of your time working remotely, you are entitled to these rights, and you're responsible for these duties. Take a hard look. Are you truly receiving the legal rights and fulfilling the duties of modern telework? It is absolutely a question worth finding the answer to.